You raise your right hand. You solemnly swear the testimony about you before this matter is the truth, the whole truth, and anything but the truth.
Good morning. State your name and record. And he was the individual that was struck in this case, is that correct? What do you want to tell me about the impact of this incident on your son or you?
As I said before, here to support my son, he's Minister of Justice, and I'm taking justice to him. And I want to see the right thing done for what she's done. I mean, I know she's young and all, but like anybody else in this country can commit a crime, any time, nothing. You know, it's very hard for me to be here. I'm a single mother taking care of him, and see her mom was victim that day. It's not just something I can forget.
How's your son?
He's doing fine, having slowly, eating, acting. I'm not saying. He's got a little weight in his face here, slight polish. Mentally physically like he's scarred, and I'm scarred. I can't forget about it. It's I'm here every day. Finally got, birthday, same funeral. Like I said, I'm here to support my son. I want to see what he's done. I want to see his every time, just like everybody else. Me, if I do a crime, I want to do my time. Everybody loves their kids. I understand that. Okay, she's still young. She has a lot of chances to do. She needs to do life. But that's no excuse. She needs to do her time like everybody else.
Thank you.
You're welcome.
Anything else about the witnesses?
No.
All right, I'm going to, I'll look to you on, if you want to make further argument on this. I want to understand that I'm not getting to the college yet. Depending on what my perspective is on sentencing, and you may not even receive so college, I want to do this first to prove the inmate's time. So I don't want to say that because I think my mind up to what you're doing now. All right.
Your Honor, as stated in the Commonwealth Sentencing Memorandum, the Commonwealth believes that their recommendation is appropriate based on the seriousness of the defendant's actions that evening, that day. Judge, they're nothing short of egregious. Mr. Savanhmixtay was a 12-year-old boy that was hit with such impact that he essentially flew 50 feet into the air. With such impact that a piece of the defendant's motor vehicle was found in his leg by doctors at Children's Hospital and then later matched to the defendant's motor vehicle. It not only the vigilance of the Lowell Police Department as well as the Lawrence Police Department, it could very well be true that the evidence would have never been uncovered. The defendant took such steps to avoid detection after the fact by going to an appointment and then by filing the police report to Lawrence Police and bringing the motor vehicle to a body shop to be repaired while Mr. Savanhmixtay was left laying on the street with these serious injuries. And based on the actions that were deliberate and calculated, the Commonwealth does believe that the split sentence is appropriate under the circumstances, and that the period of conditions following it will give the defendant the opportunity for rehabilitation in the future as well. So we are asking for the split sentence based on the...
Gentlemen, please keep it quiet. Thank you.
We are asking for split sentence based on the egregious nature of the charges in the deliberate calculated actions that were taken out of the fact to cover up the hit.
Your recommendation is specifically what?
The recommendation by the Commonwealth Judge is guilty, 2 years house of correction, 6 months to serve, balance suspended for 2 years, with the National Highway Safety Course, the Brains at Risk Program, 100 hours of community service, and a 1-year loss of license.
Judge, thank you. There's absolutely nothing that I can say or do that minimizes the egregious facts in this case and the serious nature of the injuries that young man suffered. It is a tragic case from beginning to end, no matter what this court does in terms of its sentence. The tragedy has happened, the impact has been felt, and it will continue to be felt long into the future, not only by the family, the victims who were injured in this accident, both physically and emotionally, but also, Judge, my client who stands before the bar, and her family, and everyone whose lives have been touched by this young woman. I submitted a number of letters in support of the sentencing memorandum, and I could have submitted 100 more, Judge. And I know Your Honor has read them. Some of them are some of the most extraordinarily eloquent letters I have ever seen or read. To talk about a young woman that is not the person that is portrayed by the Commonwealth in this case as a careless individual who acted without a thought to the injuries of this young man. I submitted medical records, Judge. Excuse me. I submitted a detailed medical report by Dr. Daniel who detailed extraordinary events in this young woman's life. Events that any one of us that suffered through. I'm not sure that I would have had the strength to stand before the court or have endured the things that this young woman has endured in her life. They're unspeakable, and I'm not going to speak of them here in court. Your Honor has read the report. Suffice to say, Judge, that those incidents in her life, I think, and the doctor concluded, has had a dramatic impact on her ability to cope with stressful situations. He concluded in his report, for example, that she suffers from delayed stress syndrome. And as a result, in stressful times, her mind does not function in a normal fashion, and it may cause her to act in a particular way that appears to the rest of us to have been a careless abandonment of an injured young man. But, Judge, I believe in my heart that is not the case. What my sister asks for, I cannot say is not a reasonable recommendation. That is what the statute provides for, but the statute also provides great leeway to the court to consider many, many, many different factors. The history of this young woman is spotless. She has never been in trouble a day in her life. She works. She goes to school. Even since this incident, although it was difficult for her to get out of bed on some days and take a breath and take a step, she did what she had to do to try to live a productive life and to do things to support her family, her friends, and everyone who has supported her. Your Honor, we can exact a pound of flesh from her, but I'm not confident that that does justice. There's nothing that this court can do that could assuage the pain and the suffering that the family of this young man has had to endure. Nothing. No jail sentence will ever make them whole emotionally, and maybe not even physically, though I understand that this young man has made a remarkable recovery, and I can only thank Providence for that. Your Honor, I'm asking, coming before the court, hat in hand, knowing that the facts of this case are egregious, but I'm seeking something extraordinary, and I'm seeking the mercy of this court, the forgiveness of the family, and the hope that with what I have put forward as a sentence, it will allow this young woman to become a productive member of society, to make a contribution so that other people can see and learn from her mistakes and recognize that we have a deep responsibility, particularly when we get behind the wheel of a motor vehicle, to everyone else, to yourself, to anybody who be affected by a misjudgment. And that's what this is. And I would say, not only a misjudgment, but it's also a misjudgment influenced by outside factors as well, which I believe and I have detailed on the previous occasion. I know I've spoken for a long time. I appreciate the court's consideration. I'm respectfully asking you to impose the sentence which I have asked for, and any other terms and conditions which the court sees fit to impose short of incarceration. I think the impact of incarceration would be disproportionate to the notion of justice in this case. And again, I would respectfully ask the court's mercy.
Well, I've reviewed all the material that the parties provided me. I've followed up a lot. I've read the case twice now. And I recognize the tragedy of this case all around. the SEC has stated that the factors that under consider among other than my sentencing decisions are retribution, rehabilitation, punishment. And I think I need to balance, I know I need to balance the Commonwealth needs as well as those of the punishment. I agree, as I stated before, there's an egregious back pattern. I can't state that strongly. I would adopt the Commonwealth. So I don't know if we need to proceed to a college or whatever. If you're going to consult with the client if you wish to, and otherwise we'll withdraw.
But given the nature of the disposition Your Honor is suggesting, what I'd like is a trial date so I have an adequate opportunity. But I would like to ask the court for an interim date prior to trial to see whether or not we would be able to accept the court's recommendation.
I can give you, a status date, but it's going to be relatively quick. And that's fine. Today is May 6th. I'm going to suggest May 27th.
Your Honor, I'd like to be out of the state on May 31st. Could the court indulge me to the second?
No judges. Judges. How about the
Again, I'm a state judge. Every Friday. I'll do that now.
June 13th in this court tonight?
Matter is now continued to June 13th. The status.
Thank you.